We'll head back to court in just a moment, but first, let's bring in National Trial Attorney Michael Jaafar. Michael, of course, thank you for joining both of us on the show today. Listen, this trial is something else. The more I watch the videos from different angles inside the convenience store, now we're listening, and what he is saying does not seem to match up to what we see on the videos. What do you think this means for the defense?
I mean, Taz, their client was lying to the police. The bane of every criminal defense's existence is the day that they get the exhibit list from the state when they're getting ready for a trial, and they see on the exhibit list, hey, we plan on introducing the interview we had with your client. It's the bane of every criminal defense attorney's existence. I promise you, it's the worst thing ever. We coach our clients, look, don't talk to investigators. You're only going to make things worse. You mentioned the case of Nicholas Mew in the prior block, right? Like, it never, ever, ever helps you. I can't tell you how many defendants get convicted purely because they lied to investigators. We don't know if they were guilty or not. We don't know if they did it or not. But people lie when they see that badge, when they're out of their comfort zone and they're sitting in the room with investigators, they are going to lie. Lying is something that's ingrained when you become a kid and you're in trouble with your parents. You lie, you find out, hey, this is a solution to every problem I have right now. If I just lie to mom and dad about what I did, it's the solution to everything, right? But when you're in front of investigators, you could tell in that video, Judge Ashley, he thought he was talking with friends. He thought he was talking with people who agreed with him. The investigator who interviewed him did a good job. He lied to them, and this is going to bode very poorly for the defense. The attorneys are having a heartburn with it.
Yeah, it's tough, you know. And again, he does say, though, I will say, that it all feels like a dream.
Yeah.
So it's hard to really sort of say, you know, he was actually lying, or that's just how he remembered it. But anyway, Michael, stand by. We're going to get back to court now. He's not acting like a guy who feels like he's done something terrible. You know, I think he seems to be honest, even though some of the facts don't match up. I think he's telling what he believes happened. Let's bring in our guest still with us, National Trial Attorney Michael Jaafar. Michael, here's a situation. Shop owners in North Carolina have a right to detain. They have a right to use reasonable force. This guy brings a knife to this particular confrontation. What do you make of it?
The Shopkeepers Act of North Carolina allows them to detain. It's for the purposes of a lot of these shop owners. They have the ability to automatically lock a door from the inside and lock a person in until they either give up the confiscated, the stolen goods, or until the police show up. It does not allow a person to murder somebody or use any kind of a deadly force. The Shopkeepers Act, if I was his attorney, I would have lost weeks of sleep waking up and thinking, but there's a Shopkeepers Act. You know, it's got to help me in some way. And every time you analyze, every time I've analyzed it in this case, I come to the conclusion, yeah, but it doesn't apply. It just does not allow like you basically went from like, you know, being on floor 1 to being on floor 90, right? Like within a second. So I think his attorneys would have lost a lot of sleep thinking, well, there's a Shopkeepers Act. There's got to be a way it can help you. It helps you with the beginning of it. It does not help you with the end of it. The way that this whole entire interaction ended is grossly different than how it started. It's not within the purview of the North Carolina Shopkeepers Act. The privilege by North Carolina was to allow Taz Zarka to detain this young man if he even had a suspicion that he stole anything, not to do what he did. So I just don't think it's going to help him.
Because it's not reasonable force. Now, we haven't seen all of the videos from the surveillance, and that's because part of it's just too graphic. We're not going to show the actual stabbing. So I think there are pieces of that are really important to the jury, Michael, that we can't see. But I want you to comment again on the fact that here's a person who I think did shake a hand, stood up when law enforcement came in, and he's just cooperating and telling the story. The problem for him is he's doing that and telling, even if it's what he remembered, which is very different from the videos. And I think that's why you keep telling defendants, don't speak to the police initially.
Yeah, he believes he's in the room with friends, and he's not in the room with friends. The fact that the state brought this video in the second day of trial shows me that they believe that this proves their case, and it proves that he murdered Mark Garrity. So the fact that they brought it is that tells it all, right? There's been some cases where the defense we bring these believe it or not, once in a while an interrogation video actually absolves a defendant. It's very few and far in between. Most of them cleave in favor of the prosecution. So the fact that he's in there, he had 2 different outfits, he had 2 different days. He believes he's in the room with friends when in fact he's not.
Yeah, that's the case. All right, we're going to see what happens in that case.